day to you all, my treasured viewers. Do you know that if a marriage is void, it affects you, the partner in that marriage, or the party to that marriage? And that if a marriage is voidable, both partners are affected. And the effect does not end with the partners or the parties to the marriage. It also affects relations and the families, all the families involved in this marriage contract. Hello, my name is Ogochukwu Onoha, your usual anchor person. And the channel is Human Rights Heralds, a half hour with a human rights wizard. On our previous video, we talked about the difference between customary law marriage and statutory law marriage. Today, still pursuing, still dwelling, or still focusing our attention on the marriage matter, we are talking about voidable marriage and voidable statutory marriage. Voidable marriage, whether customary or statutory, and then voidable statutory marriage. I am sure that this void or voidable needs further explanation so that you get to understand them better. Before I do so, remember to like this video and share it. You'll be doing us a good turn, but also serving the entire society if you help us to share this video and get others to also benefit from it. I also encourage you to subscribe to this channel so that you can get our videos firsthand. And now to the business of the day. If your marriage is void or voidable, it affects everyone who is concerned with such a marriage. Therefore, our topic today is one that affects the nooks and crannies of our society. The Matrimonial Causes Act was a law of the Federation of Nigeria, made an act of Parliament, Nigerian Parliament, made in 1970. That act of the Nigerian Parliament, that is the Matrimonial Causes Act, spells out the conditions under which an existing marriage can be dissolved. So the Matrimonial Causes Act provides steps that lead to the dissolution or putting an end to an existing marriage. In law, if any action or event is void, it means it has no effect. It is ineffective or ineffectual. And if any action, event, or situation is voidable, that means it is not void at the moment, but possibly contains elements that can make it void, especially if it is referred to a law court. And today we are talking about void and voidable marriage. Let me rely once more on the Matrimonial Causes Act of 1970. That law provides 5 conditions that make a marriage void, ab initio. When we say ab initio, we mean from the beginning, which means that it provides 5 conditions that makes it impossible for a couple to even be married at the beginning. Please, I would like to refer you to our immediate past video where we discuss the customary marriage, the customary law marriage, and the statutory law marriage. But just for your information, to help you understand this video, customary law marriages are based on the custom, and statutory law marriage is the one contracted under the English law of the Great Britain, that Nigeria inherited during the colonial period. It is the statutory law marriage that leads to what we today refer to generally as the white wedding. On our previous video, we discussed the conditions that make a customary marriage valid. These conditions, more or less, also apply to the statutory law marriage. Their non-existence, the absence of these conditions, makes a marriage void. That means it's of no effect, it does not hold from the beginning. That is ab initio. Then the Matrimonial Causes Act of 1970 also provides five other conditions that can make a marriage voidable. Now, there are a few points I'll rather explain immediately. If a marriage is void, anybody, any interested party, can go to court to challenge that marriage and make sure that it does not hold. Anyone at all. But if a marriage is voidable, that means that the marriage is valid. The marriage has been contracted, and two of the parties enjoy and can enforce their rights, the rights that belong to them or the rights that accrue to them in that marriage arrangement. The marriage already exists, but it's voidable. Voidable implies that it contains elements that could make it void if someone goes to court to challenge the marriage. Now, if a marriage is void, it does not hold from the beginning, and no party to the marriage has the right to enforce any right, because no right exists at all. So if a young man, as a suitor, has been visiting the family of his bride-to-be and spending money on his bride and his in-laws-to-be, and the wine carrying, the introduction is done and he spends money, there is wine carrying and he spends money as usual, then along the line, somebody raises an issue that results in a court case, an issue that makes it impossible for the wedding arrangement to go on. That is what we mean by the marriage is void ab initio. And no one is entitled to any right. So the man loses all the money he has spent. And the bride's family, if there is any expenditure they have made on their in-law to be, lose such expenditure. No one has a claim to make because the marriage is void. A voidable marriage, however, is valid. It already exists. The man and his wife already live as a family. And yet, there are elements in that marriage that make it voidable. It is called voidable because a third party may or may not go to court to challenge the marriage. If nobody goes to court, then the marriage remains valid. But if someone goes to court, it is possible that the court could declare the marriage illegal and dissolve it. That is why it is voidable. If a marriage is void, not voidable this time, anybody can challenge it, even after the death of the couple involved. Anybody can still challenge the validity of the marriage. I'll give you an example. On our last video, it was said that customary law marriage or marriages do not apply to strangers. So a stranger who is not of a particular culture can come to that culture and marry a woman in line with the culture or the marriage custom of that culture. If it happens, then the marriage is void ab initio. That means the marriage never held, even though the man and his wife may have lived together and have children. In the case of Morphoy and Seneca that I discussed on our last video, a man from Sierra Leone lived in Lagos many years, studied in Lagos, got married to a Yoruba girl, according to the Yoruba marriage culture and customs. But when he died, the attempt by his wife to take over his property and begin to run his property was halted by a brother of the man who claimed that his brother's property belonged to him and not to his brother's wife, even though his brother's wife had children of both sexes. When the mother appeared in a Lagos High Court, the court ruled that the Sierra Leonean man and the Nigerian woman were never married in the first place. And so the woman had no right to control the man's property. And so his brother, having an inheritance link to the man, being of the same blood, inherited his brother's property. So that is what we are talking about here. That even if the partners to a void marriage are dead, anybody can still challenge that marriage, contest it in a law court. However, if the marriage is voidable, no one else can challenge or contest the marriage except the couple involved. Only the man, because a voidable marriage is already valid, the couple is married. Only the man can challenge the marriage or his wife. No one can challenge the marriage except those two. And if anybody can challenge it, then it can't happen during their death. It must happen in their lifetime. That means a third party can challenge a voidable marriage only when the couple is still alive. Either a third party or one of the parties to the marriage can challenge a voidable marriage. But no third party can challenge the marriage after the death of the couple. So, I guess that is clear. Please, we have a comment or a question, an observation. Drop it on the comment section and I will get back to you. Remember our aim here: to educate Nigerians by simplifying the language of the law so that the ordinary person gets to understand what the law is saying. And by doing so, to empower our people to know their rights, to protect their rights, and to defend their rights. Now let's talk about the first condition. The first condition that makes a marriage voidable. The first is the marriage age. Now we have explained the difference between void and voidable. The marriage age. If the two people intending to get married are not of the marriage age, that already makes the marriage voidable. And if they get married, anybody can challenge their marriage, can contest it, and get a law court to dissolve the marriage. Unfortunately, the Matrimonial Causes Act of 1970 does not say anything about the age at which individuals are assumed qualified for marriage. And because of this, people from the individual ethnic nationalities and cultures in Nigeria have their own peculiar age of marriage. We are aware, for instance, that in the Islamic culture, the age is 13, 12 for the male and 13 for the girl child. Now, in the old Eastern Nigeria, the Eastern Nigeria House of Assembly tried to address the situation by passing the marriage age law of Eastern Nigeria. That law was passed or was adopted as law in 1958. It says that the marriage age is 16 for girls and 12 for boys. That is the marriage age. That law still exists. It is still valid. So if a marriage exists, but the two people involved, the couple involved, the parties to the marriage, are not of the marriage age, the marriage is voidable. We say voidable because it contains an element that could make a law court dissolve it if somebody challenges it. The second factor that can make a marriage voidable is statutory marriage. Let us assume that the marriage is contracted in the customary marriage, and it is discovered after the marriage that one or both of the parties had married before under the statutory marriage. That is, had married before under the Marriage Act. The statutory marriage, that is, marriage according to the English law, is done under the Marriage Act. The Marriage Act came into force in 1914, and Nigeria, upon independence, inherited it from Britain. So, the discovery that a man who is now married to a woman in the customary way had once wedded another woman in a church according to the statutory marriage. The discovery can make that marriage voidable. That means it can result in the dissolution of such a marriage if someone challenges it in a law court. We have mentioned two factors now. Then, the third factor that can make a statutory marriage voidable is consanguinity. Consanguinity. This concept was discussed very well on our previous video. Consanguinity means blood relationship and marriage relationship. Those who are related by marriage are also related by blood. What this means is that the law forbids marriage between blood relations, those whose blood relationship is very close. So, marriages between first and fifth cousins are illegal. I discussed this very well in greater detail on our immediate past video. Please watch that video. A man, for instance, can marry his wife's sister. And a woman in marriage can't at the same time marry her brother-in-law. She can marry her husband's brother. Yes, we know that in certain circumstances, in the African culture generally, a young woman of a childbearing age can marry her husband's brother, but this usually happens if that husband is already late. And rather than promote promiscuity, that is, leave the woman to start running about and then leading a promiscuous life with men, the family arranges for a brother of her late husband to remarry her, to inherit her as a wife and play the role of a husband to her. This is okay. But we're talking about a situation where both husband and wife are alive. The husband can marry his wife's sister or cousin or step cousin or niece. A husband can marry his mother-in-law, that is his wife's mother, or a sister to his mother-in-law, or a daughter to his mother-in-law's sister or his mother-in-law's brother. These are close blood relations. However, sometimes if the blood relationship is assumed to be distant, then through the special permission of a high court or the governor of the state, the marriage could be contracted. And if it's already contracted, it could be allowed to go on. 3 points. Factors that render a marriage voidable, that is, a statutory marriage voidable. 1, marriage age. 2, statutory marriage. 3, consanguinity. Now we'll talk about 4, consent. A very important point. There must be consent. That means there must be proposal by a man and there must be acceptance by the woman. Or there must be a proposal by the woman and acceptance by the man. It can go the other way, even though most of the time it is the man that proposes. But it can go the other way around. So there must be acceptance. Acceptance means consent. The acceptance cannot be obtained by threat, or by duress, or by force, or by deception, or through the ignorance of one of the parties. Once it is discovered that the party gave his consent or her consent under duress, that is under force, or fear of something, or under threat, or under the influence of alcohol or any kind of intoxication, or through deception or through ignorance. Once this is discovered, the marriage is void. The court will dissolve the marriage. Now, in the event that one or two of the parties to a marriage are illiterate, then there must be an illiterate juror. An illiterate juror is somebody, juror is spelled J-U-R-A-T. An illiterate juror is somebody who is educated and who can explain the conditions involved in marriage, in a marriage contract, to the party who cannot read and write. And it must be ascertained that this party understands the terms of the contract thoroughly, or at least appears to understand the terms of the contract thoroughly. Otherwise, the marriage will be voidable. Good. So, consent is very important. Therefore, marriage by misrepresentation is voidable. I give you an example. A Nigerian man in the USA is engaged. So, a young woman in Nigeria, and is expected to return for the marriage soon. And then suddenly, he gives information that he is returning to consummate the marriage. And on the marriage day, on the wedding day, and on all the other occasions that involve the marriage arrangement, his brother in Nigeria, younger or older brother, it doesn't matter, impersonates him. That means disguises as the real person. A brother that resembles him disguises as the real person. And the bride is not able to identify the fraud or misrepresentation. So they get married in a normal way, wedding and everything. And then, over time, she expects to be taken to the US because her husband promised that after the marriage, They'll go to the US together. Now, in a short while, the young man realizes that the person she has married is not actually the man that has proposed to her. This realization already makes the marriage voidable. The marriage cannot hold because it was done by misrepresentation. The party to the marriage, one party, the woman, married someone he believed was another person, and that was erroneous. There was a case in England. The case was titled Velia versus Velia. An Italian young man who could not speak or write or understand English very well visited London and soon ran into a young woman who fell in love with him. Then in a telephone call, the young woman invited him, informing him to come over to a location where he would sign some documents. So the Italian got there and signed the documents. Later, when they had left the location, the young man told him that what he had signed was a marriage certificate and that he was now her husband. Of course, the young man refused. And when the mother appeared in a lockout, the court voided the marriage. The court declared the marriage null and void. It did not hold because the young man was deceived. He did not understand the whole arrangement that led to his signing a marriage certificate. He was not there to get married in the first place. Now, we've talked about consent. We've talked about the consent of, we've talked about giving consent and how important it is. Now let's talk about the sixth point, the sixth factor. The sixth factor is conformity. Conformity with the law. That the marriage must conform with the provisions of the law. What are the provisions of the law? For a statutory marriage to be valid, the couple or the parties have to go to the local government registrar. In every local government in Nigeria, there is a registry, an office called the local government registry, where an official called the marriage registrar works. That is where documents will be given to the parties to the marriage to sign, and they will provide details after filling some forms. After filling the form will be displayed on the notice board of the local government for 21 days. A part of the conditions in the form they fill is that one or both parties to the marriage must have lived within the environment where they are to get married for a period not less than 15 years. One or both of them must have lived in that environment for a period not less than 15 years. Now, after they have signed, after they have filled the form will be displayed on the local government notice board for 21 days. At the end of the 21 days, they will come and collect their marriage certificate. They will sign and collect their marriage certificate. And a copy will remain in the file of the local government. During this period, if the parties to the marriage, the man and the woman, are members of a church, every Sunday, the church will announce their banns, B-A-N-N-S, banns. It's an announcement to members of the church, the congregation, that Mr. This and Miss That are planning to get married on a named date. If you have anything that will make this marriage not to hold, say it now or keep quiet forever. At the end of the 15 days, from the point of view of the government of Nigeria, the couple are married. What usually follows the white wedding is just a ceremony. Whether there is a white wedding or not, what happened at the local government is called a registry marriage. A registry marriage. It is the only legal marriage apart from the customary one that takes place in the custom. It is the only legal marriage. And in Nigeria, it is superior to the customary marriage. It is this local government registry marriage that many Nigerians erroneously call a court marriage. No, it is not a court marriage. It's a registry marriage. A law court does not unite partners in a marriage. A law court doesn't. The law does not give a court that power. However, it is marriages that are made in the local government registry that the court has the right to dissolve. So what the court has the power to do is to dissolve a marriage conducted or a marriage contracted under the law. That is a statutory marriage. But the court doesn't unite the couple. It separates or dissolves the marriage if the marriage runs into a problem or the marriage is voidable, as we are saying here. I'd like to give you another case, a case that illustrates something of this nature. Now, it was the case between the state and Prince Will. What are we referring to here? Conditions that make a marriage voidable. Now, we've talked about the local government registry and church marriage. But I need to add before I move on that there are licensed places of worship that conduct white weddings and also issue their own marriage certificate as a support to the one issued by the local government. But that marriage certificate is the inferior one. The real marriage certificate is the one issued by the local government registry. Now, there are many churches, however, that are not licensed to wed or issue a marriage certificate, and they do it. The marriages they contract are illegal. And the pastor, reverend, deacon, or whoever is a religious minister, who, knowing this, does not tell the couple he is wedding that they should go to the local government registry first and obtain a legalization of their union before coming to the church. If the matter appears in a law court, it will attract 5 years imprisonment for the pastor or whoever presided over such a marriage. Now, we move on to the 7th factor. That factor is called bigamy. Bigamy means to marry again while you are in one marriage, a statutory marriage. Bigamy attracts 5 years imprisonment if the accused is found guilty. A man who is wedded to a man statutorily, a man who had a statutory marriage with his wife, cannot marry another woman while his wife is still alive and while their marriage has not been dissolved by a law court. If the marriage hits the rock, that is, there is a crisis in the marriage, one of the two parties might propose a divorce. If the other party accepts it, they could go to court and the court would dissolve the marriage. And then each of them will be free to remarry. Very often, marriage problems intensify and the couple separate. The man might pack his properties and move away. Might pack his belongings and move away. Or the woman might move away with her children or alone, leaving the children for the man to take care of. Whichever is the case, no matter how long they stay apart, they are still married in the eyes of the law. And it is a marriage crime, a crime in the law. A crime in the law. And it's not a crime against the partner, it's a crime against the state. So the trial is usually the state versus somebody, like that of a state and Prince Will, which I'm going to talk about in a couple of minutes' time. Because a crime committed in marriage is against the state, not against the partner. The partner is simply a part of it. So unless a law court dissolves the marriage, marrying another person by any of the two parties amounts to bigamy, and bigamy attracts 5 years imprisonment. Now to the case between the state and Prince Will, which I already mentioned. Prince Will got married under the Marriage Act, wedding and all that. He was a Christian. But along the line, he got converted to Islam. And then he married one more wife. Islam allows its men to marry up to 4 wives. Prince Will is now a Muslim. But his marriage with his Christian wife has not been dissolved by a law court. It is still valid. So when his wife went to court, or sued him to court, it became the state versus Prince Will. And he was to serve 5 years in jail. But because his lawyer pleaded ignorance, that Prince Will didn't know that leaving Christianity to become a Muslim would still forbid the apostate, that someone who has changed his faith, would still forbid the apostate from violating a Christian law. So he didn't know, in simple words, he didn't know that having joined Islam, that he had no right to marry again unless he dissolved his first marriage. So because of that, the judge commuted his punishment, that is, lowered his punishment. And instead of 5 years, he was sentenced to 1 month imprisonment with hard labor. So, ladies and gentlemen, I hope you've enjoyed today's discussion the way that I've enjoyed it. If you enjoyed my company the way I have enjoyed mine, then you've made my day. I'd like to ask you once more to like this video and share it so that other people, other Nigerians out there will avail itself of its rich content. Then subscribe to this channel so that you'll be getting our videos firsthand. Remember our goal: know your rights, protect your rights, and defend your rights. By so doing, you will be able to get others to respect your rights while you respect theirs. And in this way, we will gradually enthrone a harmonious and orderly society. I will invite you to join me on our next video, where we still continue our focus on the family and marriage law. There is so much to be done, to be discussed here, so we've just started. Till then, take care of yourself and stay out of trouble. Goodbye.